SJC-13665 in the matter of an impounded case.
Attorney, good morning.
Good morning, Your Honors. David Cherney, Atwood and Cherney, Boston, on behalf of the appellant, who I'll refer to because of the impoundment, in this case as KS. This is a case that presents to the court with what I see as the lower court's clear error in applying the law as it's written. This is a case that involves a young girl that was born out of wedlock, and approximately 5 years and 2 days after that birth, the mother filed a complaint against my client, KS, to try to establish paternity in the case. After the child had been born, there was another man, QT, who I'll refer to as QT in this case, who had signed what's referred to as a VAP, or a voluntary acknowledgement of parentage, under Mass General Laws, Chapter 209C, Section 11. And the purpose of 209C, Section 11, the paternity statute, is to provide for the establishment of paternity for children that don't necessarily have an involved father. The way that this happens is that the voluntary acknowledgement of paternity is signed by the father, and that unless within 60 days of signing that, he seeks to revoke it, or unless within a year, for purposes of fraud, duress, or a mutual mistake, he seeks to invoke it, it becomes non-challengeable.
May I ask you a question?
Yes.
And I'm not going to be able to remember everyone's initials, so I hope if you don't mind if I just refer to your client as the biological father and the party to the voluntary acknowledgement of paternity as the non-biological father. How does your client have standing to challenge the validity of either the voluntary acknowledgement of paternity or the effort to rescind the voluntary acknowledgement of paternity? Right, as I understand it, your client was not a party to that agreement. So can you maybe address the question of standing?
Sure. My client's not seeking to challenge the execution of the voluntary acknowledgement of paternity.
But he is seeking to challenge the rescission of that agreement.
He is. And it was brought within the context, when you look at it, it's a bit of a convoluted procedural background. We've tried to lay it out in our brief, but there were 6, I believe, maybe even 7 separate actions filed by the mother in this case.
But the only action brought against your client was what?
It was a complaint to establish paternity filed on April 6th of 2022.
Right, so that's independent of a voluntary, that can be brought independent of any existing or non-existing voluntary acknowledgement of paternity, correct?
We say, given that there was an established father in this case, and that's what the VAP did, it established the parentage of this man as the child's father, that it was improper for that case to even go forward. And that was raised...
But you weren't a party to that case.
I'm sorry?
You weren't a party to that case.
To the earlier case? No, we were not.
Your client was not a party to that case. So how do you... And no party to that case has challenged the outcome of that case. So how do you have standing to do that in this appeal?
What we're saying is once she filed against him to establish paternity, he raised validly as a defense that there already was an established father in the case because of the voluntary acknowledgement of paternity that could have been revoked within a year, but it was 4 years too late at that point. This was happened 5 years, 2 days after the child's birth. The statute...
Does the child have, I'm sorry, does the judge have any flexibility, I'll call it the magical equitable powers, to do what is in the best interest of the child and set aside the deadlines that are in the statute?
I don't believe it does.
And why not? What's your best legal authority for that proposition, that the judge's hands are tied to do equity?
I think the issue was addressed in the paternity of Cheryl case that this court heard, as well as the The other recent case decided back in 2023, it was JM versus CG, I'm sorry. And they talk about the fact that this was a statute that was drafted by the legislature that did not provide for the type of discretion, if you will, that a judge might have to say the time frames that are set forth in this very straightforward, specific statute of 60 days and 1 year, that a judge on conditions can exercise his or her equitable powers to avoid or to change the deadline set forth in this case.
Even if the judge determines that the best interest of the child is to do that.
Even if the judge makes that determination.
So you're
yes.
saying that, what is it, paternity of Cheryl and CG, those two cases held that the judge can't weigh the best interest of the child separate and apart from the deadlines in the statute?
Well, there's discussion in those cases about a court's use of its equitable jurisdictional powers.
Was it in the context of a best interest of the child analysis? I'm curious. I am not familiar with the cases presently. So
Hard to say, I guess, is my best answer I can give the court.
Wasn't it, I mean, just to follow up on Justice Wendland's question, in those two cases, there's an existing bond with one of the parents, right? And the court preserves that bond by not allowing challenges. I may be getting the two cases confused. Here we have the opposite, which is the child has no father, essentially, because the other father, I mean, I understand your points on the statute, but this child is going to be left with no connection to the biological father. In those cases, there was another father in place who was taking care of the child, wasn't there?
Well, in those particular cases, you had fathers who were seeking to come in and be established as parents in the case. Here, it's sort of the flip side of that. We have a defendant who is saying the statute prohibits this case from going forward.
So that doesn't the best interest of the child needs a dad of some sort.
In this particular case, to the extent it could be considered evidence, because what actually happened is Judge Barber in the case asked questions of the parties at one of the hearings, at the January 2023 hearing, and they responded. There was no examination or cross-examination in a formal sense, but they did give testimony in court, so I'm going to consider that as evidence. But in this particular case, that evidence was that the, to use Her Honor's term, the putative father, if you will, the one who had signed the acknowledgement of paternity, had spent time during the woman's pregnancy, had supported her emotionally and financially, and that for a couple of months after the child was born, supported the child emotionally and financially. So to the extent there was any...
And then that relationship was severed.
Then that was severed at the behest of the father in that case. He
So
stopped
currently, there's no emotional attachment between the child and this putative father, as you call him.
That's true. And I think that the circumstances are that, you know, we have a situation where there are many cases where a father is absent from a child's life, and it's an unfortunate situation, but that's what happens. And we have laws that have been established to try to allow for a parent to be put in place to either provide financially or to have a parent who can have, in some cases, people who are looking to establish a bond with the child as the child grows. But here...
Do you have any legal authority for the proposition that the fact that there is already a legal father precludes a judge from determining that another man is actually the child's biological father?
Well, I think that the two cases that I cited, paternity of Cheryl and JM versus CG, talk to the issue of somebody coming in to establish, affirmatively establish
Seeking to
themselves.
establish.
So this is sort of the reverse of that.
Right,
But
so I guess the answer to my question is no.
there's no case that has decided this issue.
Right.
Somebody who is looking to
Okay,
avoid...
so what would preclude the judge from doing that? And maybe in that context, you could address the new statute, 209C, Section 26.
I was going to say, under Section 26 of the new statute that just went into effect last week, I guess it was, January of this year. There are provisions that talk about, in certain circumstances, a court can find that a child has more than one father.
Right, in the best interest of the child is
Right,
what.
but there are a whole series of requirements under 209, Section 6 that would need to be met in that particular case.
So is the answer here that the case needs to be remanded for determination under that statute?
Well, first of all, I think 209-26, the new statute, I don't know, that's not a retroactive statute, first and foremost.
Oh, okay, but it's these cases where just like, right, there've already been 6 or 7 complaints filed. There would just be another complaint filed.
Well, first of all, my client is not the petitioner in that case. He would not be the petitioner, and as I read the new Section 26, it would require the petitioner to be the one who would meet all of those standards, things like that the plaintiff was engaged in constant caregiving of the child, that he had resided with the child for a period of time, that he undertook full and permanent responsibilities for the child. And there's a whole series of 7 different areas that a court would look at to make a preliminary determination.
What is the language you're relying on? I'm looking at subsection A.
Okay, I'm looking
I
at,
don't see that there.
I'm actually looking at Section 25I that talks about subject to subsection J, the court shall adjudicate a plaintiff withstanding in a proceeding, and that sets forth the standards or the requirements that the court would need to find. And the burden would be upon the petitioner in that case to establish those facts that the court could make that finding on.
Okay,
Here,
so you're not saying that within section 26, there's any such requirement? You're relying on section 25I?
25I is what I say is the statute section that would allow the court to make the finding, essentially, for lack of a better term, to have 2 fathers in a particular case. And on the facts of this case, there is no way that my client could fit into that category. First and foremost, as I said, he would not be the petitioner in those circumstances, or a plaintiff seeking the establishment of that relationship. So I think that's the key, and that's why I don't think that the new statute would be applicable. When I
So
look
why
at,
is it that we cannot just apply section 26 ourselves? The case is pending on appeal before us. It's really not a question of retroactivity. In
Well, I
other words,
think
the case is pending when the statute comes into effect.
well, that's an interesting question, Judge. I understand what you're saying, but this case, I think, is still
I mean,
governed.
it wouldn't be, that's where remand would come in. It's not that I'm saying we would decide what's in the best interest of the child, but the statute came into effect while the case was pending on direct appeal.
I don't think that the court can then apply those new standards to a case that had been existing, especially here, where that
I'm not
issue-
suggesting we would apply it. I'm suggesting why
suggesting-
can't, I'm trying to understand your assertion that it's not retroactive, and I don't understand how retroactivity would apply to a case where the statute comes into effect while the direct appeal is pending.
I'm saying in this case, given that there had been an established parent early time frame, that the court can't now have this new statute. We're going to then apply that to a case that's been sitting on the books for some 6 years at this point. So I really do believe that I was trying to analogize it to, I guess, to a case where there's an evidentiary ruling made early on in the case, and that evidence comes in, and that sort of sets the tone for a trial, and there's a trial, and for example, in a criminal case, somebody's found guilty and they appeal. And the court makes the determination that that evidentiary ruling had been an incorrect one, and but for that ruling, the case would not have had the result it did. I think it's very similar here, except that we have a statute, not a bit of evidence. It's a statute, and it's a clear statute. I have to keep coming back to that. And I know I've said that a lot in my brief, and I know I've said it a lot in my argument today, but I think that's the real issue that needs to be looked at here. Section 11 says that if it wasn't done in that time frame, it can't be done. It becomes unchallenged and unchallengeable. And as one of the amicus said in this case, equity can't be used to circumvent a statutory requirement, and that's what we have here. I see my time is almost up. If there are any questions, I'd be very happy to entertain them. Otherwise, I'd rest on the issues to the extent I haven't orally argued them as set forth in my brief.
We have one question, sure.
Is there a statutory requirement to do what is in the best interest of the child for the probate court in determining?
209C11A does not have that discretion
But
afforded
I'm not asking
trial judge.
about that statute. Are you aware of any statute that says that a probate court judge determining issues related to child custody, care, support should not consider the best interest of the child?
I spend a lot of time in the probate courts. We all know that the standard is always best interests of the child.
Okay.
But here, that standard can't vitiate the statute.
Okay.
Thank you, Counsel.
Thank you, Your Honor.
Good morning, Your Honors.
Attorney Schaefer.
May it please the court. I'm Pamela Schaefer on behalf of AD, the appellee in this matter. I think you all have brought up some important factors in this case, particularly the substantive case law that the appellate court in Massachusetts has looked at does not mirror the facts in this case. It's particularly historically the opposite, where there have been most often fathers who are seeking to establish parentage, not to avoid it or to say that they're not the father. And in this case, where there has been no substantial relationship with this child by either party, and that early on that the non-biological father, if I may steal your language, that has been determined to not be the father, and early on both the mother and the non-biological father realized that although they didn't take action legally to change the birth certificate without the knowledge, they acted as if that was what they were doing.
Isn't that a problem for you, though? I mean, I get it that this seems really, leaving this child in this state doesn't seem to be in the best interest of the child, but the way your client and the other, the non-biological parent acted is sort of inconsistent with our VAPTURS approach, right? That we discourage you from signing those things. Once you sign them, you're on the hook, and we don't want you saying, "Oh, the kid doesn't look like me, therefore I'm getting out of this." So that's a problem, isn't it? Because
Certainly. I mean, I'm not suggesting that that should be taken lightly or that that is an appropriate way to act. However, in this particular case, the non-biological father had acted in a way that, and the mother both, that they both believed that truly he was the father. And I believe, within the hospital content where he signed the birth certificate, it's not in a legal setting. It's not in a setting where it's as comprehensive to know those rights, and they don't set them down as well as these two parties believed that they were doing what was right for the child, where they understood that he wasn't. They did this early on, and they did do a genetic test.
Until the biological father shows up, he's not really doing what's right for the child, right? He's signed on and left this kid without a dad. He doesn't act within that year. At first, he steps up and he does all these things, and then he signs that form, which we discourage you to do unless you're sure, right?
And I'm sorry, I don't mean to.
And he didn't have able counsel like you at the time. I mean, she doesn't have able counsel, so that gets into a whole nother set of issues. But I just feel like if we go the way you want, we're undermining these VAPs, which are really important, right?
Well, I think there's significant case law, even, there's cases that have reflected even married people who have had similar situations where a particular case, sorry, forgive me if I have to just check my notes so that I don't quote the wrong case, But in CC versus AB, where there was a married couple who had separated, and the wife in that case had met someone else, had a baby, and lived with her significant other. He had signed the he did not sign the birth certificate. It was acknowledged that because she was married, her husband was the father. And they had lived together, he had established a relationship with this child, and then their relationship broke down, and he intervened to say, listen, I'm the father. She may have been married to him, but we lived. This child was several years old, and it was allowed because he had established.
But that's not our circumstance here,
Was that a?
No.
right? I mean, that's a big deal.
What I'm saying is that in certain circumstances, it certainly isn't appropriate to open the floodgates. In some cases, if we change the law or allow people to just void these.
Can I ask you, what was the legislative purpose in the 60-day rescission period in the 1-year window for mistake of fact?
So the legislative purpose was really to protect children and to look to making sure that people don't take these things lightly, certainly, and that a child has that certainty. And in that event, I think in this particular case, the issue is not that it was taken lightly, that once they realized it, was only, the child was only a couple,
There's no bad faith in this
couple
case.
months old, that they
But-
didn't
but-
take the steps to
let me ask you,
change that.
Could a legislative purpose be that when one enters into a VAP, they need to go into it with the eyes wide open, and it can be rescinded
From a
in
legal-
60 days, just for no reason at all, and then for mistake of fact within a year,
Yes,
right?
yes, and I think.
Could that be to protect the person who signed the VAP?
I think it's more, I think legislatively, the primary purpose was really the child, Your Honor. I think that, certainly from a legal perspective, it's intended to say, if you're signing this, you need to be sure, right? There's that language that says you better really know, and oftentimes offering of genetic marker testing. That wasn't the case here, and it's not an excuse.
So given your answer to Justice Gaziano's question, that the legislature has determined as a matter of policy that this 60-day/1-year window is enough time, and after that, the best interest of the child is to stay with whoever signed the VAP. Why would the judge have any equitable pixie dust to change that legislative determination?
So I think it's, kind of twofold with what you just said. So best interest of the child wouldn't blanketly go to just because someone signed a VAP, right?
But that's what the legislature has determined. After the 60-day window, 1 year for fraud, mistake, whatever.
So the legislature has determined that it would be in the best interest of the child, if you take that standard, that applies to, basically that standard applies to a relationship with the child. That's expecting
Well,
that this person
there's
has.
nothing, as I can see, in section 11 that says if that signatory had a relationship with the child. It's just full stop. It's final after 60 days, absent these extenuating circumstances. And even then, after a year, that's it. And it says nothing about the relationship between the child and the signatory.
But it doesn't get into the best interests either.
But that's what I'm saying. Your response to Justice Gaziano's question was that the legislature determined that it was in the best interest of the child to have the bindingness of these VAPs. I'm wondering why the judge then suddenly gets to question that legislatively determined best interest.
So I think the way, specifically in this case, and generally the best interest of the child is applied, and Judge Barber was looking at this, is that the best interest of the child, as the legislature applied it, is expecting that someone who voluntarily signs a birth certificate or a VAP, or both, is committing to that relationship and committing to be there for the child, not only just on paper, but in actuality.
Well, and financially supportive-wise.
Correct.
Right, because we don't want children born out of wedlock, for lack of a better term, to have become wards of the state.
Absolutely, but
So it's not only about the bonding, one would hope there'd be a bonding, but it's not only about that bonding.
That's correct. And historically, when the best interest of the child standard has been applied, even in these cases where it's typically men and most of the background of cases where there's been somebody looking to make an exception to that time frame or to come in after several years have passed, that's when the issue has moved towards the best interest of the child in looking at whether there's a substantial relationship of that party with the child on either side, whether it's the biological or non-biological father, and how that would affect the child.
But there is no case where there's no relationship between the biological father and the child, is there? Where we allow a judge to exercise equity in order to force a relationship between the biological father and the child?
Well, historically, our legislature has encouraged that biological fathers step up. That's what comes with genetic marker testing required by the court and having that happen. The only issue here is that there was somebody else who signed the birth certificate. If there hadn't, there absolutely is a public interest in having any genetic parent
So what's the
participate.
limiting principle in your scenario? When is Section 11 binding, and when is the judge allowed to exercise a second look after these time periods have lapsed?
I think, that it's a pretty case-specific and fact-specific, and in this case, that there's so many facts that support it, specifically not just that, early on there was a coming together of both the mother and non-biological father realizing that although he signed the birth certificate, that this was not a child that was genetically his, but that then from that period forward, and that was maybe not 60 days, but certainly under a year that occurred.
So why does that militate in favor of the other side? Wouldn't that militate against you? Because, again, they're not lawyers, I understand that, and I understand that the guillotine that would come down with a statute of repose is terrible. But in this case, they knew, they had some indication that the non-biological father was not the biological father. So there's an opportunity at that point to say, let's go and take care of this within the 1-year window, and we don't. So now you have the opposite, where if the legislature's informed deliberation is it's in the best interest of that non-biological father to stay stepped up, and he doesn't. He does the opposite, right? He says, I now know I'm not the biological father, so I'm out.
Well, yes, however, it's not about the best interests of the non-biological father.
No, I'm talking about the child. That's the reason, back to Justice Wendland's point. You've got the 60 for no reason at all. You've got the 1 year within whatever the statutory factors are. So now it is, if you're not going to avail yourselves to those safety valves, now you're on the hook under the VAP. And it's in the best interest of the child to keep you on the hook because now you have not taken advantage during that time period. Why isn't that? Again, I understand the sympathies may be with you. We know that the biological father is the biologic father. There was genetic testing and all of the things that may come with that, financial support, whatever, what have you. But I just wonder why that doesn't work against you.
I think because that there, within all the case law that, again, is primarily about fathers challenging to want to be involved as opposed to our scenario. I think in all of those cases, the thread that it binds them together is that the weighing out of the best interest in the child, not just limiting it to someone who needs to support them or somebody has a relationship or somebody who has genetic consequences, that all of those pieces together, and then when you bring them in together and how those facts affect the particular situation.
What if the putative father was very wealthy and the biological father was not? Could a judge then say, you know what, it's actually and nobody has a relationship with the child, as in this case. It's, it's better just to let the VAP lay, because from a financial perspective, it's better for the child to be tied to the more wealthy individual. Would that be allowed under Section 11 in your view?
No, not in my view. I think it goes back to what you were saying earlier, is that the best interest and the statute are not focused on one piece, or they're not just focused on the financial
all
obligations.
things being equal, neither man has a relationship with the child, and the only distinguishing feature in my scenario is that one is more wealthy than the other.
Yeah, I think if they both have a relationship with the child?
No, neither of them does.
Oh, neither of them does.
I think that's the case here, right?
It is the
Yeah,
case
okay.
here. I think it would still go to the history, and if there had been a financial contribution ongoing, in this case, it was for a very short time. This child is 7 years old now, there hasn't been any. But if there had been that, along with any other pieces that
Can I
would,
follow up on that then?
Yes.
Isn't the best interest of the child here,
Yes.
both of the dads are, accidents dads. So wasn't it the best interest of the child to have a continuing obligation to support that child from the get-go? And wouldn't that put the burden back on the father who signed the VAP? Because this is just, okay, 23andMe finds this guy 7 years later, but this child hasn't had anyone supporting.
well, and I'm sorry, I think that's
ahead.
part of the statute that allows for, it's not perfect. Certainly, it would have been better if it happened from day
But
one, but
doesn't-
can go backwards for the child support to help to take care of that. There's,
Yeah, but that's why I'm wondering whether the legislature's purpose is in the best interest of the child, because it ensures that someone's supporting that kid, and we're not in this kind of continuous, this biological dad may luck out and not have responsibility for a child that he put into the world, but the best interest of the child seems to be having someone legally on the hook to support that child from the get-go, right?
and I wouldn't disagree with you there, but I think there's two pieces in this case that change that. Is one, it didn't, and there's no changing that from the time frame perspective, but there's the ability to change it and going backwards. Certainly, the court has the ability to do retroactive child support to birth, and it doesn't change what happened in the past 7 years, but it certainly can take care of that concern, and that could happen with either of these fathers in this case. And then you have, the piece of the genetic. So not only can this child have the financial potential from either father, the relationship potential if either father wanted it, although they don't seem to. But then the other piece is, there is a genetic piece in knowing your history and knowing your genetics. This father doesn't have to participate in that, but then this child will have that link to at least have some way to know some of that and be able to pursue that. That's something that I think is important. If you have no other factors that could compete, that's a piece that's important as well, with all things being equal.
Justice Gaziano, may I ask a question? There are very few statutes of repose across the law. Are you aware of an equitable exception to any of them?
So I don't have a specific occasion that I can give you that, Your Honor, but I can tell you that 209C wasn't meant to to eliminate the equitable powers of the probate court. They certainly still exist in addition to, even though it is a statute of repose.
So I take it that you're just not aware of, so I can think of statutes of repose in certain kinds of medical malpractice cases and certain kinds of property cases, but I can't think of any of them having an equitable exception. It seems to me contrary to the whole notion of
Well, so
repose.
if I may, actually, in CC versus AB, the court specifically states that 209C places no limit on the equity jurisdiction of the court. So I would say, at CCNAB does actually specifically go to that notion, and then also in Godin v. Godin, although that's a Vermont case, looks at that as well, is that there's certain times when the equity jurisdiction remains for that purpose, and that it needs to look beyond the statute. There's also, certainly,
That's interesting, because Godin, and I'm sorry, Justice
Please,
Cassiano,
yeah.
Godin says there's a fundamental policy concern that requires finality of paternity adjudications. And so I thought that was a curious cite, and I did not understand why you would rely on that one.
that is interesting, but the reason I rely on that is because they also state in that case, particularly that issues concerning parental rights and responsibilities are of the utmost importance and do not always lend themselves readily to rigid legal rules. And that's part of Godin as well. So I think that court was also, looking to weigh out all of these pieces and recognizing that, these are people, these are children, families, and that we can't always legislate every particular scenario that might come up. And the equity jurisdiction needs to be in place for that purpose.